Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now moving on to our first program today. It is my distinct honor to introduce our speakers. We have Mark LeHocky and Judge Anita Santos presenting on legal ethics, applying legal ethics to actions, a guide to the practicing attorney's ethical compliance, competence, and confidentiality. Judge Anita Santos joined ADR Services, Inc. in 2022 after 8 years as a judge of the Superior Court of the County of Contra Costa with assignments in the Family Law Division, Felony Criminal Trials, the Juvenile Division, and the Domestic Violence Calendar. The majority of her time on the bench was spent presiding over numerous contested and complex family law matters. In addition to her years as a judge presiding over family law matters, Judge Santos served as Child Support Commissioner for 2 years, where she presided over thousands of short and long cause hearings regarding child support, spousal support, and attorney fee requests. Prior to her appointment as the bench, Judge Santos was a sole practitioner in an active and successful family law practice. Thank you so much for joining us today, Judge Santos.
Thank you, Ms. Jones. My pleasure in being here.
Thank you. Our other speaker this morning will be Mark LeHocky. Mark has been managing and resolving hundreds of cases nationwide for over 30 years by bringing 3 varied perspectives to his work. As an attorney representing large multinational corporations on both the plaintiff and defense side, as general counsel implementing early mediation programs at both Dreyer's Ice Cream and Ross stores, and as a full-time neutral since 2012. Having participated in countless disputes as a client, litigator, general counsel, and neutral, Mark recognizes the challenges faced by both corporate counsel and litigants alike. This background gives him a unique, holistic perspective that allows him to identify strategic opportunities and frame disputes in the greater overall context of business methodology and relationships. His practical ideas and creative solutions allow him to approach matters from every angle, whether the company at hand is a small business or a global conglomeration. Thank you so much for joining us, Mark.
Thank you, Katie.
And I will go ahead and hand the program over to the 2 of you. Let me pull up our slide deck here and take it away.
Great. Well, thank you, Katie. We can jump ahead. So as you know, our agenda is to talk about the California ethics rules that were revised a few years ago, and also to fill in as to a number of very interesting interpretations of those rules that have come down during that time period, and ideally to apply the rules to ethical issues that impact compliance, competency, and confidentiality issues. As you'll see, sometimes the intersection of those 3 subtopics gets very interesting in terms of what people's ethical obligations are. But before we do that, I just want to kind of acknowledge, I think we have a very good sized turnout today. I was asking before we officially started to see if we have a polling function. I know we don't have it activated, but if we have that polling function, I'd love to ask the question entirely anonymously as to whether people are taking this class because they have to get those ethics credit in, or they just have a dying interest in the topic of ethics.
Mark, I think you know the answer to that question.
Your Honor, I agree with you. But with that in mind, and I was one of those people up until a few years ago myself who said, oh, do we have to? Hopefully, what we're hoping to offer as part of this time together are some kind of practical insights, things that will make us all better lawyers, better advocates, and in turn also improve the client relationships. So keep in mind there's a strategic aspect to this conversation, not just a compliance aspect to it. But to kick things off, Judge Santos, I think maybe the best part is to start with what is the background of the conversation with respect to we call the recent rules, and you can provide a better explanation as to why that's relatively new territory for everybody in California.
Yes. Okay. So if we could go to the next slide, please. And I will start with saying it was 2018 when there was the first revision in over 3 decades of the rules of ethics for attorneys. And that happened when there were 69 new ethic rules that were instituted between 2018 and 2019. The rules that we have now in California track the American Bar Association ethic rules that have been adopted in other states, including the way they number those rules. It was a long process in the revisions that we are now operating under. And it was a very detailed and cumbersome process to change those rules. There was a committee that issued a series of rules. They initially were all rejected and then redone and then adopted what was started in 2018, including followed by formal opinions regarding ethics and ethical issues. So during the last 100 years, the practice of law has grown exponentially. The growth has affected not only litigants and citizens, but attorneys, the economy, and the courts, of course. Throughout California, we were the only state that did not track the ABA rules until this revision in 2018 and 2019. Historically, in 1989, our governor at the time, Governor Duke-Majan, signed Senate Bill 905 into law, and that was continuing the legal education bill. The idea was that attorneys would study important ethical concerns as part of their practices so they can have increased awareness of ethical principles and integrate those principles into their practices. So the 3 C's that we'll say several times throughout this presentation is confidentiality, competence, and compliance. And those were the original guiding principles when SB 905 added section 6070 to the Business and Professions Code. That's the one that mandated this course and the other 25 hours of legal education that we all have to have and have to be approved by the state bar or offered by a state bar provider, with 4 of those hours in legal ethics. And as you know, there's some other requirements as well as the legal ethics, but that is the codification of that requirement. I have to look at my notes to remember all the sections. And let me caution you, just like we're going to try to make this a little less dense and a little more enjoyable, if that's the right adjective. But some parts of it is impossible. So please just understand that giving you the history, though, I think is important. All right. So where was I? In 1989, the legislation required the state bar to request that the California Supreme Court adopt a rule of court authorizing the state bar to establish and administer the MCLE programs. And in 1990, the court adopted 9.31, provisional legislation that authorized the state bar board of trustees to adopt more detailed rules. And later that same month, December of 1990, the board approved the MCLE rules and regulations, and they launched on February 1st of 1992. So that's what, 30 years ago now?
Yeah.
Wow. And I know there's some of you attending weren't even born at that time. However, many of us were. So at the beginning of the 21st century, the number of lawyers in the state had increased dramatically over the previous century. That, coupled with a rise in the number of lawyers, was a substantial increase in lawyers who engaged in multi-jurisdictional practices. I just happened to notice that one of the chat notes was a lawyer asking about if this counted in Florida. Prime example. The California Supreme Court Chief Justice decided that rules needed to be greater in uniformity and national consistency in both practice and application and in consumer protection. So that was what provided the catalyst for change.
So as part of those changes, Judge Santos, I understand there was a change with regard to the definition of what a person is. And with the implications that it has a much broader meaning than it used to. Would you care to address that change?
Let me go to that section. Yes, that is in Rule 1.0.1. The definition of a person is quite broad. It says that a person has the same meaning as stated in the Evidence Code section 175 and is defined as a natural person, firm, association, organization, partnership, business trust, corporation, limited liability company, or public entity. So that is the new definition. And of course, that covers all or almost all of lawyer-client relationships.
Okay. So it is, Judge Santos said, we're going to try to make this a little more lively. So you'll see shortly, we're interspersing some video clips and things to give us some reminders. I think we're all living in the world of video clips, especially over the last few years. If you've been watching what's been happening in Washington, it's a wealth of ethical examples that we can reflect on as we think about some of these rules if we're practicing California. And many of those actors involved there were in fact are practicing in other locations, but they're good reminders of different intersections where lawyers are in what appear to be some pretty controversial areas. In some cases, advising clients not to remember when it appears they may actually remember. Advising clients that financial backers may be in play who would really appreciate that they testify in a certain direction. So in addition to what we're reading here, I think one way to kind of get a refresher on all these issues is pick up the newspaper almost weekly. But moving forward, Katie, can we go to the next slide? So I think this is me. And in terms of the competency issues, the one of the interesting things is as Judge Santos referred to before, the California Supreme Court, for the most part, approved all of the proposed new rules, adopting the ABA standards, made some modifications to others. The one proposed rule that was not approved has to do with an attorney's obligation to clients with diminished capacity. So we don't have an official rule similar to the others on that, but I've already forgot what the initials stand for. The body who issues the formal opinions issued this one opinion, 2029-207, that provides some guidance in dealing with very practical issues of diminished capacity. So Judge Santos, you have more comments, or should we move to the next slide?
Let's go to the next slide. We're continuing
yes, on that topic. So using that as sort of the kickoff point, there are situations, and these are actually the 4 examples in the formal opinion, definitely worth reading, by the way. And I think, if I'm correct, the links that we provided link to the official site, which not only provides the rules themselves, but access to each of the formal opinions we reference. So we're not going to take deep dives in those formal opinions. But if you're dealing with any of the sub-issues, as we're talking about, especially, well, this is a great example, diminished capacity questions, definitely worth the time to read those opinions. They're very thoughtful and very thorough. So let's talk through some of the examples. So Judge Santos, you have a situation where the client demonstrates indications of diminished capacity and nonetheless wants you to take actions on their behalf in a variety of examples. And one might be opposing a conservatorship application. So obviously we don't have a whole detailed fact set, but what are your initial reactions in terms of the attorney's competency obligations, and what do you do in that situation?
Well, if you have, this hypothetical is presuming that the person that's making the request has some competency issues, and you cannot ethically proceed full force on their actions when you yourself are aware of their competency or lack thereof. So a person who is not fully competent is not someone we as attorneys can ethically represent and zealously represent unless and until we get that situation resolved. And that could be their own conservatorship or some type of remediation on a professional level. And that's exactly what that opinion talks about and gives examples of.
And I take it your response would be the same as the second bullet, a request to change their will, to juggle beneficiaries, to add people, drop people, if there were questions about their competency.
It is. Another thing you can do as an attorney ethically is to have your potential client or your client evaluated. I mean, we are not professionals, we attorneys, we judges, even we are not professionals, are not able to say, especially when competency has such a variation in their extremes. You can just be the beginnings of dementia versus full-on Alzheimer's, for example, and there's different levels. So you can enlist a professional. One of the things the decision talks about to evaluate the person that's trying to get you to take these actions. So that's another alternative other than just decline.
Right. Well, and I'm old enough to remember not the remake, but the original television series Lost in Space, where there was the robot and the constant refrain, danger, Will Robinson, danger. So I think as I'm going through some of these bullet points, that comes up in the back of my mind. So the next one would have to deal with a situation where there's a request to enter into a contract on behalf of the client who may be suffering diminished capacity, but the request for the contract is at the request of a relative. So diminished capacity by the client, but some relative is asking the lawyer to get involved in entering into some new contract or making a change in the contract. Same kind of response, same type of concerns, Judge Santos?
Yes, absolutely. And we're going to talk about it later in the presentation, but you also have to be cognizant of who is your client and who is directing your actions. We have other contexts that we'll discuss it in, but this particular hypothetical, that's an additional concern.
Correct.
That you have if the potential client is asking you to enter into or change some status on behalf of a third party. So.
Right. And the last bullet, I think, is really an interesting one. I have to admit, when I started to read the opinion, I was erring on the side of uber caution. I shouldn't use the word Uber anymore. Extensive caution. In terms of a client who's approaching you for help, who may acknowledge, may even tell you they're concerned about diminished capacity, and they want you to provide some help because they're concerned about their capacity worsening. What I thought was most interesting about that opinion is the conclusion that no, the lawyer can still help, keeping in mind that the client is concerned about their diminished capacity. And then going back to Judge Santos' prior comments, it all has to be juxtaposed against their condition at the time you're having the conversation. So it's not a full stop. It sounds like you really have to take a measured approach. Would you agree, Judge Santos?
Absolutely. Absolutely.
Right. Yeah, more on that point.
I have no more.
Okay, so let's move ahead on the slides. And I think we have a clip, maybe it's coming up next.
Following this slide.
Right. So Judge Santos, you care to cover this territory to start out?
Absolutely. And this is one of the more obvious ethical concerns, and not some are more subtle. And so it's good to start here. And this is now Rule 8.4.1 that prohibits discrimination and harassment as to any client in or operating in a law firm. It requires lawyers to notify both the Department of Fair Employment and Housing and the EEOC, I'm forgetting all the acronyms, but to make any lawyer, and we'll go into more detail, to make a report of any actions that they observe and actions taken by the state bar. And it also requires, in more the most dramatic change is all levels of all lawyers to take corrective measures when they see or are aware of improper conduct by the firm or other lawyers or firm personnel. And that includes the newest associate taking action against the most senior partner. I mean, give you the two extremes. So this rule was a dramatic change. And there's, of course, a case we're going to discuss that highlights that dramatically. It seems like a no-brainer now, but it wasn't a no-brainer as short as 20 years ago. And some would argue even more recently.
I'm going to interrupt Judge Santos only for a minute to apologize to everybody. I had a power outage last night. My electricity has been coming back on in stages and my television just turned on. Give me one moment. Keep going, Judge Santos.
Yes. All right. And so the new rule prohibits law firms from knowingly engaging in discriminatory hiring, firing, training, and compensation decisions. What that means is that a lawyer or firm that violates the rule if they fail to advocate for corrective action. The new parameters are more expansive than the preceding rule, which was 2-400, and essentially prohibits discrimination on medical, marriage, genetic, and veteran status, just to name a few of the categories. Under the former rule, 2-400, the state bar could not initiate any disciplinary proceedings until a tribunal of competent jurisdiction, to quote the language, determined that the conduct had occurred. Of course, that's a huge hurdle that had to be in place. And even then, the bar's finding was only admissible evidence in the disciplinary proceeding. The bar could not discipline the offending attorney or firm until the finding of misconduct in the other tribunal had become final. So the list that I recited is not all inclusive, but in short, any firm or lawyer, discrimination is now prohibited under 8.4.1. There are some attorneys that are concerned about the broad rule. It reaches too far into gray areas or even courtroom behavior. And it is true that demonstrating bias or prejudice in the courtroom is problematic, but it does not expand to motions or other evidence that is protected under the First Amendment. So we have a clip from an older movie that was, I think, a movie before its time that that raises this issue. It's entertaining. And of course, the movie is filled with twists and complications that makes it not quite an easy answer. But we're going to watch that now and then pick it up again after the clip.
Excellent.
Excuse me. Am I being fired?
Let me put it this way, Andy. Your place in the future of this firm is no longer secure. We feel it isn't fair to keep you here when your prospects are limited. And now, I don't want to rush you out of here.
We've got a committee meeting.
Wait, excuse me, Charles. With all due respect, this is preposterous. It doesn't make any sense.
Oh, you're right, Beckett. You don't have an attitude problem.
Take it easy, Walter.
If you had lost confidence in me, why'd you give me the Highline suit?
Andy, you nearly blew the entire case, for Christ's sakes. That alone is inexcusable. It would have been catastrophic for us.
Uh-huh.
So you were concealing your illness?
That's correct.
All right, explain this to me like I'm a 2-year-old, okay? Because there's an element to this thing I just cannot get through my thick head. Didn't you have an obligation to tell your employer you had this dreaded, deadly, infectious disease?
That's not the point. From the day they hired me to the day I was fired, I served my clients consistently, thoroughly, with absolute excellence. If they hadn't fired me, that's what I'd be doing today.
And they don't want to fire you for having AIDS, so in spite of your brilliance, they'd make you look incompetent, thus the mysterious lost file? Is that what you're trying to tell me?
Correct. I was sabotaged.
I don't buy it, counselor.
That's very disappointing.
I don't see a case.
I have a case. If you don't want it for personal reasons.
Thank you, that's correct, I don't.
Well, thank you for your time, Counselor.
Okay, so before we go on, I just have to comment, and I'm sure most of you, or many of you saw Philadelphia. That movie was a wonderful movie that touched on so many issues, the attorney-client relationship. As you probably know, he did take the case and ultimately won on behalf of Tom Hanks' character. If Tom Hanks' character dies, their relationship develops, but that was an example of obviously prohibited discrimination. And so just if you haven't seen it, I recommend it. Mark, did you want to comment on the clip?
Well, yes. I mean, interesting in pulling things together, and Judge Santos gets credit for pulling together the clips. It's interesting also to watch something, in this case, a film that is 30 years old. It's just amazing how time is flying. But a 30-year-old clip that at the time seemed more of a gray area in terms of inappropriate behavior, unethical behavior. Thankfully, watching it now, it seems a little more nostalgic, not okay by any means, but I think it's also a reminder how much progress we have made, certainly in parts of the country like California on issues like this, but obviously far from done. So yes, a moving film, but hopefully we're 30 years better at this too. So let's maybe jump to the next slide.
Yes.
Yeah, and so this is an interesting area. We were just referring to Rule 8.4.1, which prohibits harassment, discrimination, retaliation. And again, when you think about all these rules, Judge Santos, it seems like you have to really keep them in mind together, how these rules interact. So do you want to, I think we talked a little bit about Rule 5.1, 5.2. Do you want to recap this and address it further now?
Yes. All right. And so I agree. We absolutely have to consider all the rules together. There'll be some that seem to conflict that we'll discuss a little bit later, but 5.1 and 5.2 require the duty to supervise and the duty to speak up. So I touched on this already, but managing and supervisory lawyers have a duty to make reasonable efforts to ensure that their firm has in effect reasonable measures, giving reasonable assurance that all lawyers in the firm comply with the rules and the State Bar Act. And 5.2 specifically addresses a subordinate lawyer's duty to comply and to speak up. The defense of I was just following orders, or that's the culture, or I told my supervisor even, is not sufficient in regards to an ethical violation if they have seen or heard questionable conduct. When there is an ethical question that can be answered reasonably in two different ways, it is permissible to follow the supervising lawyer's direction. But if the supervising lawyer's answer would lead to an ethical violation, then again, the subordinate lawyer must express her or his contrary opinion to the supervisor. There's a famous, for some of us, but a groundbreaking case, Baker v. Weeks, that is a live example of this circumstance. Did you want to talk about that, or would you like me to talk about the Baker v. Weeks one?
Well, I'm happy to just mention it briefly. Also interesting, again, in the category of, boy, the time is flying. Also, almost 30 years ago now, that it had involved a case where a partner who was apparently a serial harasser of women, and the lawsuit ended up imposing substantial penalties on the firm and the individual lawyer, who of course left the firm afterwards. But what was striking as the case developed back in those days was this was not an isolated incident, which raises all the issues that I think are implicated by 5.1 and 5.2. And your mind immediately goes to what's going on around a firm like that if this person has a track record of inappropriate behavior. And I think the significance of 5.1, 5.2 is the other attorneys, not just the so-called managing partner, assuming there is one with somebody with that title, but potentially all the attorneys have responsibility if they're exposed to that and fail to take appropriate action.
Yes.
Judge Santos?
I was just going to comment that that case was 1994, 1 year after Philadelphia, that it at the time resulted in the largest punitive damages award for sexual harassment. It was the compensatory damages were only 50,000, and I'm looking for the punitive damage award.
I think it was 6.9 million.
That's right.
Which was a lot of money back then.
Oh yeah, it's a lot of money still for some. Absolutely, and it just slammed home. And of course, the attorney was egregious, groping and commentary and comments and behavior was horrible. But the firm knew about it, had previous complaints. So that's the case that kind of began. I call it the early Me Too, but not, of course, here we are, and with our own equivalent in Hollywood and all over in many places. But absolutely, the duty to speak up and the duty to supervise are now the rules. We do have now on screen on our slide that's up a couple of hypotheticals, or they're not hypotheticals, just circumstances that are clearly, I think, ethical problems and that would be a violation of these rules. Refusing to represent anybody. In this hypo, it's transgender people. It could fill in the blank with any particular group of people. And then actually, the second example was something that back in my district attorney days, we had a very similar circumstance, although you weren't taken into a private viewing, but there was daily review of female attorneys' attire. Of course, that was some almost 30 years ago, but these examples are meant to bring home the ethical violations that this involves.
Now, I'll ask Judge Santos, obviously unacceptable behavior, no question. And in this hypothetical, say, for example, the firm, the office manager insisted on approving of everyone's attire on a daily basis. Would that change your thoughts about this example?
That's interesting twist on that. I guess I would need more facts, because not necessarily. I mean, there's nothing wrong with having dress codes, for example, but there's very, very gray areas on what's appropriate and what's inappropriate. So to make it not gender specific, that certainly brings in a new question. So I wouldn't say, oh no, it's still inappropriate, but I mean, you got to remove the private viewing. What do you have to do? Do you have to spin around, or is it just a mere, no short skirts, above the thigh level or whatever, or no, I don't know, orange ties. I'm just kind of making it up, but absolutely not necessarily. If it's I would need to know more facts on what the process is, but that could be appropriate and not a violation of the ethical duties if it's done, in a non-harassing way.
Right. Well, in the reason we have all three of those rules cited, the first two again is the duty to speak up rules, both for senior people and take action, not just to supervise, and duty to speak up by subordinate people, and 8.4.1, which is the anti-harassment, anti-discrimination. So you could be in an environment where the rule may not be, or the questionable behavior is not directed to you individually, directed towards others, but it may be apparent, I think this example, more than apparent, that this is a form of discrimination if it's directed, as Judge Santos just said, based upon people's gender. And the top issue about the firm refusing to represent transgender people would be considered in California definitely a form of discrimination. Query what's going on at the level of the United States Supreme Court in some of the cases that have to do with people raising claims that they have the ability to refuse to provide service to certain other people. But that's not here. That's not California. So should we move forward? Next slide. Okay, interesting topic, sex with a client. We're back to Danger Will Robinson territory. Judge Santos, would you like to kick this off?
Sure. Well, of course, sex has always been problematic, and I love that we can just openly talk about it now. There's an opinion, 1987-92, that pointed out numerous problems with the former rule. The former rule prohibited a lawyer from having sex with a client only if the act was coerced or if it was considered a form of payment. In the 1987 opinion, it pointed out the limitations of that rule that led to nearly 30-year discussion of whether or not a per se ban was appropriate, meaning absolutely cannot do it. 30 years. The various players in these ethical rules and revising them have been discussing this issue. And to discuss the interplay of the prohibitions against harassment, that we just finished discussing, and the complications that arise when there are intimate relationships between law firm employees as well as with clients, it's just a recipe for disaster. Let's say that. And I can tell you now that we're not hiding the ball. There's no answer that anybody has come up with that's perfect. There's plenty of discussion and differing opinions, but I will talk about the new rule, which is 1.8.10. It prohibits lawyer-client sexual relations unless there was a pre-existing consensual relationship. And this language is from the rule. The new rule is a huge change, obviously, from the former rule and the way the bar used to approach the lawyer-client romances. I will say, prior to Mark and I doing this training, there were Justice Lambden and Justice Chin that did the training, and they were personally involved with the revision of the rules and the 30-year conversation on this particular subject. You don't have the benefit of their detailed knowledge of that, but I can tell you, as I have with the new rule is, there are so many problems that arise when lawyers engage in intimate relationship with their clients. Of course, we have the big case we just talked about, wasn't a client, was an employee, but confidentiality, consent, issues being raised of being under the influence, the breach of trust, the myriad of conflicts that occur if and when there is a unpleasant departure from the relationship, whether it's unpleasant because of mutual consent or just unpleasant for other reasons. The workplace romance between two employees is what we talked about, what we have talked about and seen in other cases. However, the lawyer-client romance ends with one party often feeling slighted, and then you have the divided loyalty problems, distrust amongst fellow lawyers in the firm. It could be consensual, of course, but if and when it turns sour, the firm is vulnerable to lawsuits of harassment, breach of contract, other issues. So, as I said, we don't have a magic answer. You know the rule. All I can say is that avoid the issue if you can as an attorney, and beware. What you say, danger, Will Robinson. I say proceed with caution, or don't proceed at all. There's a choice there, but that's the short answer for the very difficult issue. Anything you want to add, Mark?
Yeah, well, I think just to highlight or repeat, I think the key issue when you're considering any of these situations is there's the situation that exists today, and then in business relationships, personal relationships, and the like, things evolve over time. And it's as things change that all of the issues Judge Santos just mentioned can be implicated or turned from neutral to problematic. Confidentiality, consent issue.
Shall we go to the next slide? This is a hypothetical just to kind of bring forth or highlight the issue. And I actually like some of the facts that are included here. This is plagiarized from earlier training, but in this hypothetical, you should consider. So at first we have a lawyer with a pre-existing sexual relationship with a lower level employee. The employee at that time has no control over legal affairs at a large corporation, and the firm that the lawyer works for takes over representation of the corporation as a client. But then the employee is promoted to be assistant to the corporation's general counsel and will be involved in all legal matters for the client. So the question we ask, and if we had interactive webinar, you could answer, but what are the lawyer's obligations? What do you think, Mark?
Well, again, thinking backwards, and this is the guiding rule for, I think, essentially everything we're talking about, what's best for the client. And in this situation, what's over on the left, you can again say, okay, well, that's okay, that's neutral, it's consistent with the rules, but then things evolve. In this case, the working arrangements of the participants evolved. And guess what? At the end, there's a potential issue where the client, in this case, would be the company. It's not necessarily always an individual, as we know. The client may have their own concerns about whether this change is problematic, not for the participants in the relationship, but for the client. So in that type of situation, at least my 2 cents would be the lawyer should either be disclosing and getting consent in a written form, or you should be having a conversation about lawyers withdrawing from the matter. Potentially doesn't necessarily mean that the law firm withdraws entirely, but other partners essentially take over the case, or other lawyers take over the case to avoid any suggestion of anything that may impact the delivery of the services to the client. I would not want to be in the law firm's position if things went sideways in the course of whatever the representation is, and then later on this surfaces and is a potential source of conflict, bill getting paid, whatever, because this thing surfaced late. But that's my 2 cents. Judge Santos, what do you think?
I would agree. I would absolutely agree. And again, as we said, there are no simple answers. There's no simple answer to this hypothetical. It's just a fact pattern that makes you think. And as lawyers, we think, right? I am noticing that, and I happen to flip to the question and answers. I can only see the number. I opened up. I noticed there's a number of questions, and there's a few that I don't know if we were going to save them to the end or if we want to jump in. They're coming along as we move through these subjects.
I'm fine, Judge Santos, if you are, if any, if you want to address any of them now, and we can also pick up any towards the end, but yeah, feel free.
Okay. Well, I'm not sure I know the answer to everything, but I'll start kind of jump around where we are now. One of the questions was, does Rule 8.4.1 apply to in-house corporate legal departments in addition to law firms? And the answer to that is a simple yes. So the ethical rules apply to all attorneys, all bodies, and encompasses all the circumstances. Another question asks if there's an anti-retaliation provision protecting the reporting lawyer in Rule 8.4.1. And so that's a no would be the short one-word answer. However, no is misleading because these are ethical rules and for us attorneys. So anti-retaliation provision would assume that the state bar would have some ability to take action against a firm that retaliated. That is not the forum in thinking this through for a retaliation. We're discussing what you're obligated to do ethically, not how a firm may respond to you. And I don't believe that I've ever seen in our ethics rules and even opinions an avenue by which those rules can be used for what you're referring to as an anti-retaliation provision. Did you want to comment on that, Mark?
No, I have the same understanding. There's not a specific provision that has to do with anti-retaliation, but as somebody who spends a lot of time doing employment work, you always have to be mindful of the steps you take, and the fact that whether it's a law firm or company, and saying we had to report this person because we thought this was what was going on, that's not a get out of jail free card. But I think this goes to the responsibility everybody has all the time. If you're going to raise matters, is to do it in a responsible fashion, provide the facts. Where I see things coming up in the employment context, actually a few days ago, was a situation where there was a bona fide basis to take certain actions with regard to a particular employment situation, but then it spun from there, and it spun in terms of comments and things that ended up leaking out of the organization, mischaracterizing what took place. And in that situation, maybe in this kind of situation, it prompted a legitimate claim for defamation. So we all have to be very careful about what we're doing if we're raising facts or assertions that suggest inappropriate behavior. But that's part of our responsibility as lawyers to do it carefully. Anyway. So that's my 2 cents. Now, did we break something? It looks like we've gone from our slideshow.
Took the screen share down while you guys are answering some questions.
Oh, okay, great.
Really apply. We will be taking a break in about 5 minutes if you want to answer any more questions in this time. And then we're going to take a break here at the halfway point to let people stretch their legs for a moment.
Well, since we have about 5 minutes, I love just Sandra's idea. Let's address the questions we can.
Okay.
So let's see. You go ahead.
There's another question regarding the clip from Philadelphia. If we replace AIDS with COVID, same result. So the question is a little confusing for me. Assuming you mean same result as in a lawsuit, a potential successful lawsuit, if that's what you mean by same result. And if so, that is a big I don't know. COVID is a pandemic versus a lone individual that was discriminated against because of their sexual status and the disease that person had. So I think they're apples and oranges. I don't know if you can replace it and have the same result. My inclination is it's more complicated than that. So, and I don't want to get too far afield, and some of the questions are going to big social issues. But Mark, did you want to comment on that?
Well, I think you're absolutely right. It's fact specific. If it was a situation where somebody is told we can't have you continuing to work here while you're contracted COVID and you may be exposing others, that's one fact pattern. As opposed to we're firing you because you have COVID, which was essentially what happened to Tom Hanks in Philadelphia. If a company was to say we have concerns about the health and well-being of all of our workers, and including you, and for this period of time that we can't reliably count on you being safe as to other people, you need to not be here. That's a different kettle of fish. But we're also dealing with a illness that is still not fully studied, analyzed. The implications of things like long COVID are hanging out there. So you're absolutely right, Judge Santos. I think it would depend upon the individual facts. What did the employer do? And were their actions proportionate to the health, whatever the risk factors are, temporary as opposed to taking adverse action because somebody in this case got ill, even very seriously ill. So yeah, interesting. And again, that's why we always have to go back to what are the total circumstances here. So should we go to another one?
Maybe one more. There is one that's interesting that it says, please address ethical rules which conflict with religious or sincerely held beliefs. For example, refusing transgender people, etc. And I think that speaks exactly to what you commented on, Mark. So I'll let you take the lead on that one.
Well, and I'm not fully conversant, you know, because it's been a while since I've looked at the storyline, but there's certainly at least one case where I think it's out of Colorado that's either before the Supreme Court, U.S. Supreme Court, or has been decided, will be decided, having to do with, I thought it was a bakery where the people who worked at the bakery were refusing. This wasn't transgender, but this was refusing to do wedding cakes and things for same-sex couples. And I thought that the context of that was they refused to do it for religious, it violated their religious beliefs. For me personally, whether they're same-sex or transgender, it's the same thing. It's a form of discriminating based on people's status. I have to confess, I don't know what the Supreme Court has done, if they've made a ruling yet, what they've done with that. But it's outside of California. It's more controversial than it appears to be in our state.
Yes, and I agree. Well, there were two cases. That wedding cake one is the first. Now before the Supreme Court is a case involving some type of web service and a business that wants to refuse to a particular class of people. But in California, that would be a violation of these ethical rules. So that's why we're here. That obviously the bigger debate will remain, and our U.S. Supreme Court will speak on that. But if your question is it a violation of the rules that we were discussing? It is. I appreciate sincerely held beliefs and religious beliefs. That doesn't change the ethical rules for attorneys.
You know, I fully agree. So Katie, sounds like we'll take a break, but hopefully we'll have time at the end to pick up any of the questions so far and any new questions. This is fun.
Thank you both. Yes, we will take a 5-minute break, everybody, and return at 9:35 with our conversation about diligence. If you would like to stretch your legs, get a glass of water. I will go ahead and play something briefly in the background, but you are welcome to step away from your computer. Please come back in 5 minutes or so.
Every conflict needs resolution. Every resolution needs people. ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, to the recruitment of the most skilled and diverse neutrals across the state, ADR Services, Inc. continues to keep resolution and legal education at the forefront and ensures that every client has a voice that fits their needs across the world. And with our AMS case management system, our neutrals, clients, and staff can facilitate communication and access their cases' information anytime, anywhere. That way, they can stay focused on what matters most. You, woman-owned and operated from the start. There is someone for every situation. Whatever the problem, we are here to solve it. We are ADR Services, Inc.
Okay, everybody, thank you for that break. We are about ready to come back. I see we have our speakers back online. So why don't we get back to it?
Back to the slides.
So I think we're at slide 13, Katie.
Yeah.
Yes, we had just a little bit more of our conversation about sex with clients.
Yeah, there's a bunch of questions there.
So Judge Santos, I think this is apropos what we were talking about in the prior slide, where might be an otherwise perfectly okay relationship with the lawyer, and then something changes at the client, the organization. So as you're interpreting the rules and per this slide, do you want to address these points?
Sure. These are just a couple of other things, and that's exactly what the first point is. And if I could just ask you to call me Anita, Mark. If the client is an organization, the rule applies where the lawyer has sex with a constituent of the organization who supervises, directs, or regularly consults with that lawyer. So that's when it's applicable, and that is that hypothetical at the end after the change in her status. And additionally, if a person other than the client alleges a violation, no notice of disciplinary charges can be filed or may be filed until the state bar has attempted to obtain a statement from the client and determine whether the client would be unduly burdened by further investigation. So, somebody, I'll just add some facts to give some realistic view of this. Somebody in the firm sees or hears some sexual activity and then makes a complaint, not the actual attorney that's having or the client that's having sex with the attorney. That is this second thing to consider. And that is actually, again, part of those 30 years of all the what ifs. And interestingly, when I was looking over the questions, you probably did too, Mark, the what about this? What if they're married? What if they get married? What if those are part of that many year detailed conversation about what's the appropriate rule, ethical rule for this issue.
Right. And this doesn't directly address the prior question about the anti-retaliation consequences, but the way I would interpret it, consistent with what I have to say, Judge Santos, it's what my upbringing is, is that obviously there was some thought given to preventing adverse consequences and people using a complaint to the state bar to do harm. So that sounds like a pretty thoughtful rule to address that. So if not more, should we go to the next slide on that topic? Okay. And this is one that I would say really interests me because it appears to suggest, although there's arguments that some of this was already here, that diligence as well as competence is specifically called for under the rules. Again, this is consistent with borrowing parts of the ABA model rules. So as the slide says, while a duty of competence has been there and continues, new rule 1.3 adds a duty of diligence. Now I got something, oh, there we go. So lawyers shall not intentionally, recklessly, with gross negligence or repeatedly fail to act with reasonable diligence in representing a client. Which raises all sorts of practical issues, which I think we want to transition to. Do we have a slide on that specifically? I think that's the next one. So Judge Sanders, do you want to start with these questions and we'll work through them? When we think about diligence, what does it actually mean? So, yeah.
Absolutely. And so the rules that we adopted that were in the last slide, 1.3 and 1.3b and 3.2 included a duty not to have unreasonable delays. So the first bullet is asking when a lawyer seeks numerous extensions to respond to discovery. Well, the response under those rules is that can be an ethical violation. You have an obligation to act reasonably, competently, and diligently. Now, the actual word is now part of our California's rules. And, everything is case specific. As a lawyer, we all know the word reasonable is subject to argument and interpretation. So the question is written the way it's written to provoke that thought. Numerous extensions to respond to discovery. Is this a one time? Is this reasonable? Is it a highly complex civil asbestos case, or is it a lemon lock car case? And so it can be an ethical violation, but the way it's broadly written here, these questions are just meant to get you to think about the obligation we all have as attorneys.
In here, I'll jump in and add, I was looking at notes from a prior presentation I did on the topic of civility. And as hopefully most of you know, there is a civility obligation built into the California Rules of Court, relatively new. I think it was adopted in 2014, and a quick shout out to the organization ABOTA, as they and their members were instrumental in driving for this adoption of the actual obligation of treating people with courtesy and dignity and civility. But in addition to that, there is in California Code of Civil Procedure, found that in my notes from the prior program, and this isn't in the slides, my apologies. Code of Civil Procedure section 583.130 says it's the policy of the state that a plaintiff shall proceed with reasonable diligence in the prosecution of an action. And the excerpt that I found was actually from the case. It's definitely worth reading, called LaSalle versus Vogel. Excuse me, not in the slides, but it's LaSalle, LASALLE versus Vogel, VOGEL, 36 Calap 4th 5th 127. And that's a really interesting case because it has to do with a lawyer who engaged in excessive dilatory conduct and then excessive litigation activity and got hit with very, very substantial sanctions for doing that. So in addition to the ethical rules we're talking about, in many cases, there are other statutes and provisions in California that you find that reinforce these principles. And if you're a litigator and you're exposed to what you believe to be inappropriate behavior on the other side, dig around and pull those out and put them out before the court if you think somebody is engaging in dilatory conduct. So let's go to the next one. So when a lawyer provides objections but no substantive response to, whoops, oh no.
Same slide, Katie.
Same slide, there we go. Going back.
Okay.
We can't exist without the slides. Thank you, Katie. So another issue which maybe impacts diligence when a lawyer provides objections but no substantive response. Essentially, they're giving the other side nothing in terms of substance. How would you treat that, Judge Santos?
I'm looking at all of these questions. or at least the first three. And same response is, it goes back to the rule 1.3 and 1.3b that talks about reasonable diligence. And no substantive response is not reasonable diligence. We know to get state bar action, it has to be egregious, but you have an obligation. We have obligations to act reasonably, and that would not be reasonable response. Same with multiple rounds of discovery over the same subject matter. Again, same rules are cited. Now, the fourth bullet here, I think this is a more clear question. When a lawyer reports to their client on the status of a pending litigation matter every 6 months, that's not reasonable. And one of the things that the new rules address are keeping track of deadlines, communicating with their clients. I believe that failure to communicate with clients is the number 2 area of discipline based on client complaints for attorneys. Number 1, which we'll talk about later, is mishandling money. But number 2 is that, and rules 1.3 and 3.2, 6 months, once every 6 months is not a reasonable contact schedule for your clients. So I think that's a more clear one, but the same response. And a lawyer just being lazy, I mean, honestly, I don't even know. Lazy has so many, so many extremes. Lazy one day, lazy for the whole case, lazy as a personality trait, but there's no way to correct everything with your ethical rules other than to tell you we have to be diligent. We have to produce documents. We have to meet deadlines. We can be sanctioned for being lazy if lazy is unreasonable. Again, degree of laziness.
And again, I think this is, I absolutely agree with everything Judge Santos said. I think sometimes this is the facts, as always, facts, drive the urgency matters. I could see a situation, for example, if a case is on appeal, especially in certain venues where appeals go the speed of molasses, where you could say, well, I'm gonna only reach out to you when I hear anything at all from where the case is or the appellate process is, and maybe a couple of months can go by. But I think the majority of time, Judge Santos is absolutely correct. To wait that long is probably a problematic issue with regard to the rules and your client relationships. And the issue about lazy, and like Judge Santos, I sit as a private arbitrator and a discovery referee. I've encountered a number of situations where the practical implications of lazy are very real for the adversaries. I can't ever obviously mention examples, but I can talk in broad categories. Number of times where one party is not pursuing their obligations in terms of responding to discovery requests, and this is becoming more and more an issue in the area where you deal with electronic discovery, where things go incredibly slow or no progress is made, and the response sometimes by the lawyers are, well, this is just hard, or we've never dealt with this before, or it's electronic discovery and everybody knows it's difficult. The short feedback I can give you from my examples is that's your problem to solve. That's why you hire e-discovery experts. That's why you bring in competent vendors. I've dealt with situations where the response is, the e-discovery vendor is just really busy right now. That's not an excuse for lack of reasonable diligence. That's and potentially grounds for sanctions, evidentiary sanctions, and the like when you have fair warning and the opportunity to address the matter. So, I think most of the things we're talking about throughout today, there's obviously a common sense aspect to all of it. And in the case of lack of diligence, the question is, what's the implication of the laziness? What has been the harm potentially to the client or the adverse party from that? And if people can show real prejudice, discovery deadlines coming up, the other side has not turned over the data. It's been multiple months with multiple turns and multiple extensions. There will be an enough is enough moment where Judge Santos or I or somebody else will say, no, it's not produced by this day, it's not admissible, or here's the sanction I have to impose. Devil's in the details, of course. Judge Santos, more on that topic?
Nope, I think we can move on.
Okay, great.
All right, let's go to the next slide, please, Katie. All right, so there have been some post-amendment opinions, and there are fewer listed here. And we're going to have to pick up our pace a little bit if we're going to get through everything. But there are post-amendment opinions. They're on the slide here, what they are. And there are a few that we're going to mention that are not in the slide. And thank you, Katie, just dropped in the chat the link to where these specific opinions can be found. The link is also on the slide and the little blue writing at the bottom of the slide. So you can cut and paste that and read these opinions for yourself. We highly recommend that you go to the opinions yourself, especially if you have a specific question or issue. But I'll start, and I can't remember, and then we're going to go share these, Mark.
No. I want you to do the difficult ones.
Oh, okay. Well, I'll do the couple that are not on the slide. Opinion 2021-206. And that is an opinion that addresses the new see something, say something rule that we were talking about earlier in the context of competency. And I know there was a question or two we didn't get to about the issue of competency. Do we have a duty to investigate? How do you know? Our own questions about that. So this opinion, 2021-206, talks about that. And I want to consider, and I didn't have the benefit of getting the updated numbers, but there are hundreds of attorneys in California alone that are over 100 years old and still practicing. Okay. And I'm not suggesting that they shouldn't be, but what I am saying is competency, one of the issues is your mental acuity. And that's just an example where we all know with age, you start having some decline. Some of us start having some decline. And so that opinion, I highly recommend it. 2021-206. Another not on the slide is 2021-205 that deals with confidentiality problems in large practices, how to maintain confidentiality when interviewing a prospective client, what kind of screening we're obligated to do to figure out if there's any adverse interests, and we'll talk about this as we're rushing through the rest of the presentation, and can clients give informed consent? So that's 2021-205. And 2021-204, that's one of the ones on the slide real quickly. And 203 and 201. Mark, did you want to comment on any of those?
Just very briefly, I do think because of time constraints, what I would strongly recommend everybody take the time to read those decisions if everybody is exposed to the potential, for example, data breaches. And again, while there's a common sense thread to all of this, the common sense thread is what's the potential risk to the client of what I'm doing. Obviously, if there's a breach or potential breach, the obligation everybody has, including lawyers, is to disclose the breach or potential breach to the clients immediately. But it also goes to thinking about how you're storing information, how you're protecting information yourself on your devices and the like, because the potential implication is exposure you may have to your client if you've not been diligent in protecting that information. The third-party funding one, again, definitely read. It raises some interesting questions, which has been part of the conversation about litigation funding for the last several years, which is who is the client and what are the obligations to the client when there's money flowing in from another party. But I think we should probably move forward and just direct people. And similarly, 2020-201, I'm going to say is the common sense concept of when lawyers depart, which happens all the time, and go from one place to the other. The fundamental question is what's in the best interest of the client. If you think about that at all times, it's not what's in the best interest of the departing lawyers or the departed law firm or the new law firm. It's what's in the best interest of the client. But I would say let's move forward and highly recommend reading all three of those.
Okay.
Oh, yes, this will be fun.
Mr. Jones, you know how an iPhone works, right? You've had an iPhone text messaging for several years now.
Yeah.
What does it mean if the messages are in blue? Whose messages are those? Whose phone is this taken from?
I don't know whose phone's taken from. I mean, I turned the phone over and said, take the stuff off.
Can I have you look in the very bottom below the very bottom left corner? Is that your phone number?
Yes. So you did get my text messages. And it said you didn't. Nice trick.
Yes, Mr. Jones.
Oh.
Indeed. You didn't give this text message to me. You don't know where this came from. Do you know where I got this?
No.
Mr. Jones, did you know that 12 days ago, your attorneys messed up and sent me an entire digital copy of your entire cell phone with every text message you've sent for the past 2 years, and when informed, did not take any steps to identify it as privileged or protect it in any way. And as of 2 days ago, it fell free and clear into my possession. And that is how I know you lied to me when you said you didn't have a text message about Sandy Hook. Did you know that?
I told you the truth. This is your Perry Mason moment. I gave them my phone, and then.
Mr. Jones, you need to answer the question.
No,
Did you know this happened?
No, I didn't know this happened. But I mean, I told you I gave them the phone over. Just
Just
And
answer the question.
you said in your deposition, you searched your phone. You said you pulled down the text, did the search function for Sandy Hook. That's what you said, Mr. Jones, correct?
And I had several different phones with this number, but I did, yeah. Well, of course, I mean, that's why you got it.
No, Mr. Jones, that's not what happened.
So I assume most of you recognize the clip, or at least Alex Jones. This is for the infamous moment in his trial, one of his trials, where the attorneys who are pursuing the claims by some of the Sandy Hook victims are suing Alex Jones. And apparently, Mr. Jones's attorneys produced a data set which reflected all these texts that referred to Sandy Hook, which was precisely the subject of one of the discovery requests of many months before the trial. And inadvertently, it sounds like, Mr. Jones's attorney turned that data set over to the plaintiff's attorney without, whether they knew they were doing it, remains unknown. It appears Mr. Jones didn't know they were turning it over. And what was also interesting is the follow-up to that is there was no apparent assertion of attorney-client privilege. And later on, the attorney for Mr. Jones told the judge that those should be withdrawn or returned because they didn't mean to turn it over. And the judge politely said, if they're discoverable, they should have been turned over months and months ago. And I think there was also an effort to seek a mistrial, which again was rejected. Judge Santos, that happened in your courtroom before?
Oh, maybe a few times here and there. Yes, absolutely.
Your observations?
Well, they're all case specific, but the point is that, my observations are there is an ethical and legal way to withdraw, and there's an ethical obligation if non-discoverable information is inadvertently given to opposing counsel or the opposing party. And that is the point of our training here. In this case, you had discoverable information that was withheld. Different answer, obviously the ethical obligation was to have discovered that information. And ultimately, this is again a fact-specific scenario, but ultimately that information came before the jury. It turns out that the steps by which any non-discoverable information could be withdrawn was not taken in this particular case, so the ethical issue was moot. And the attorney was just caught. There's a lack of a caught attorney, and actually in this case, I don't know if the client was caught, but certainly the information came before the trier of fact. So,
well, this is obviously an extreme example, but it goes to kind of one of the themes I always think about when we're talking about this. We're talking about the related concept of civility is credibility. And as we probably all know, not only was liability established against Mr. Jones, but the entire award, including punitive damages, I believe exceeded $1 billion. So lose your credibility, in this case, lose your credibility by not producing evidence and then having something like this come up. Once your credibility is gone, it's gone. So going to this very issue, Judge Santos, do you care to address these examples?
yes. Yeah, absolutely. And one big issue, ethical issue that every attorney faces regularly, at least in the criminal world, probably in the civil world, but I'll speak in the criminal world, is what if the client lies? And so we have a 2019 opinion that discusses this issue, and that's the one on this slide, 2019-200. And in that opinion, 3 scenarios are discussed. The lawyer suspects the witness in the civil case testified falsely. The lawyer is certain the witness committed perjury, and the lawyer learns of perjury after trial testimony, yet the client insists on continuing to use the perjured testimony. So that case, those issues are discussed. This is an issue that is ripe for ethical concerns, as it should be. And the question is, what do? You also need to consider the 2019 opinion on the slide, 2019-198. Lawyers have several options. That particular opinion discusses Rule 1.16a, which says the lawyer has a duty to withdraw if the lawyer knows or reasonably should know that the client is asserting a position in litigation without probable cause, a little typo there, and for the purpose of harassing or maliciously injuring any person. So that is difficult, puts the attorney in an extremely difficult position, but that is a duty that is listed under that rule and discussed in that opinion, the 2019 opinion. So withdrawing is one option. And I know in the criminal world, there's different options. Certainly, the lawyer can try to convince the client to either withdraw the perjured testimony, but not violate that client's Fifth Amendment rights. In a civil context, there's a discussion about the lawyer trying to convince the trier of fact, meaning the court, in a court trial, I presume, but to not consider that evidence. So it's a conundrum. It's a terrible conundrum if it's something that's sprung upon a lawyer, but it is an ethical obligation that we as lawyers have, is to not present knowingly false testimony, cases we know have no merit. We're going to talk in a moment about, you also have the option, and oftentimes you can settle a case. That seems to be a bit in conflict, but lawyers can settle a case and avoid the issue of the potential of lying. We have 30 minutes remaining, and I know there's a lot of issues here, but these are the opinions for you to review and think about what you do when you're caught in that situation. Even consulting with outside counsel, there's another opinion, 2019-197, that presents ethical violations. Number one, you got confidentiality. Just because it's another lawyer doesn't mean you can consult with someone else on a confidential issue. And so that's an excellent opinion to read in regards to consulting with outside counsel, 2019-197. Mark, did you have anything to add?
The only comment I was going to add, and this goes to the lower part of the slide. What do you do if a lawyer attempt to settle a case prior to withdrawing if lawyer believes client's case lacks merit? Again, I think in the real world, does it shift from black to white? Probably not. Most of the time, does it shift to, very opaque or very gray or question marks? I think that's more what real life is. The other part of Rule 1.16a is the duty to withdraw seems to be conditioned upon the lawyer knowing or reasonably knowing client is asserting position without probable cause and for the purpose of harassing or maliciously injuring any person. It appears to be a requirement for both. It's not to say we're advocating anybody assert a claim if there's a perceived lack of merit, but situations do develop in the course of real life disputes where the strength of the case seems much more opaque. That's what I encounter in a lot of mediations. And does the lawyer have the duty to withdraw at that point, or can they make the best of the bad situation? I think the reality is most of the time people try to make the best of the bad situation, keeping in mind you're neutral, cannot be party to passing back and forth any information that the neutral believes to be factually inaccurate as part of the matter. But do you make the best of that bad situation? I think most people try to do that and move on. So maybe we can move forward.
Yeah, we have a clip that is fun.
Yeah.
Go ahead.
Do you know who this is, Mr. Dixon?
No, I don't.
Well then, would you be so kind as to read the statement that you took from him on the 3rd of November, 1974? A statement, my lord, which vindicates all of these people, all these innocent people.
My lord, I need to see a copy of this statement.
Either that man or his superior or his superior's superior ordered that these people be used as scapegoats by a nation that was baying for blood.
My lord!
In return for the innocent blood spilled on the streets of Guildford, and by God, you got your blood,
Mrs. Pierce is making a
Mr.
political
Dixon.
speech. This is
You got
outrageous.
the blood of Giuseppe Conlon, you got the lifeblood of Carol Richardson, and you got 15 years of blood and sweat and pain from my client, whose only crime was that he was bloody well Irish, and he was foolish, and he was in the wrong place at the wrong time.
Mrs. Pierce, I will have you removed from the court.
And one of your colleagues, my lord, who sat where you sit now, said, and I quote, "It is a pity you were not charged with treason to the crown, a charge that carries a penalty of death by hanging, a sentence I would have no difficulty in passing in this case."
Mrs. Pierce, I'm trying to read this document. I will not tell you again to be silent, or you will be removed from the court.
My lord, this document brings the entire British legal system into disrepute.
My lord, this is new evidence.
It is shocking new evidence.
My lord, this evidence was not submitted at the trial. It is under appeal.
That, I believe, is the point that Mrs. Pierce is trying to make. Proceed, Mrs. Pierce.
My lord, I demand a recess.
There will be no demands made in my court. Stand back.
My lord, this alibi for Jerry Conlon was taken by Mr. Dixon 1 month after Jerry Conlon was arrested. This note was attached to it when I found it in police files. It reads not to be shown to the defense. I have one question to ask you, Mr. Dixon. Why was the alibi for Jerry Conlon, who was charged with the murder of 5 innocent people, kept from the defense?
I love that. Mark gets credit for that clip, and we don't need to speak on it other than.
You're not supposed to keep that note on the file. I don't understand that. I would love to see yours show up at the next trial against Alex Jones. All right. So, but obviously it's a segue to the slide that obviously there's an ethical obligation, and by the way, you will find it elsewhere in California statutory law with regard to duties of civility and honesty and the like. But obviously, Rule 0.3 says the lawyer shall not knowingly make a false statement of fact or law to a tribunal. Judge Santos, your thoughts?
We were talking about this before the clip. Similar circumstances is just bringing home the fact that even if you can't do it to other counsel. 3.3 is regards to the tribunal, the trial of fact. You cannot knowingly make a false statement of fact or law to a tribunal, failing to disclose to the court legal authority in the controlling jurisdiction, directly adverse to the position of the client, or knowingly misquoting the language of book, statute, or decision or other authority. The key word is knowingly, of course, but ethically, attorneys, we cannot hide case law. That's if you know about it, you cannot misquote or miscite or offer evidence that you know as the lawyer to be false. And it requires you to take remedial measures if you discover it later that there was false testimony. And that's what we've already talked about, what you can do.
And just to add to that, again, beyond the fact that it's built into the rules, is just think about the consequence in terms of the credibility of the lawyers who make the assertions as to the state of the law, cite a case knowing that that case has been overruled. I've encountered that more than once in the context of arbitrating and mediating. And again, separate from the fact that that's wrong, think about what that does to the credibility of the party who's making those assertions. Because if I don't believe you here, how's that going to impact how people are going to believe you elsewhere? That's Alex Jones' case. I think there is a direct link between some of that example and what ended up happening in terms of the credibility of the witness, credibility of the lawyers to that extent. So should we move forward?
Yeah, I just want to remind our audience that we have Rule 3.3. We have that opinion 2019-200 that talks about a lawyer withdrawing. One could be confused and say they're conflicting. We're talking some are civil cases, some are criminal cases involve the Fifth Amendment. You can't withdraw on a criminal case in the middle of a trial. So you have to keep the facts of the rules and the opinions in mind. And the answer is always going to be, it depends on the facts. So let's move on now as we talked about threatening. Threatening a court, threatening counsel. Mark, did you want to talk about this real quick? Short.
Well, I think the key language, and I know we are running short on time. Rule 3.1 shall not threaten to present criminal administrative disciplinary charges to obtain an advantage in a civil dispute. That doesn't preclude people from raising any issues or behaviors they think are worthy of filing a complaint, state bar or otherwise. But if you're doing it to obtain an advantage in a civil dispute, that is where you cross the double yellow lines. So this is not, the rule is not meant to foreclose people raising complaints, whether it's with regard to adversary counsel or even a member of the bench. But the key is how and why are you using it?
Yeah. One word of caution is that you cannot, as a lawyer, try to use that as leverage to settle a case. I'll report you unless you give my client, X amount of dollars. That's just a cautionary. We have another fun clip on this one. Katie, if you want to go to the next slide.
Board of Bar overseers about you today, fella. You're on your way out. They should have kicked you out in that Lillibridge case. Now, this is it today.
I'm an attorney. I'm on trial before the bar, representing my client. My client. You open your mouth, you're losing my case for me.
Now, listen to me,
No,
fella.
you listen to me. All I want on this trial was a fair shake. Okay? Push me into court 5 days early. I lose my star witness, and I can't get a continuance, and I don't care. I'm going up there, I'm gonna try it, I'm gonna let the jury decide. You know, they told me about you. Said you're a hard ass, you're a defendant's judge. Well, I don't care. I said to hell with it, to hell with it.
Look, Galvin, many years ago.
Come on. Hey, don't give me that shit about you being a lawyer, too. I know about you. You couldn't hack it as a lawyer. You were a bag man for the boys downtown, and you still are. I know about you.
Are you done?
You're damn right I'm done. I'm gonna ask for a mistrial. I'm gonna request that you disqualify yourself from sitting on this case. I'm gonna take a transcript of the trial to the Judicial Conduct Board and ask that they impeach your ass.
You aren't going to get a mistrial, boy. We're going back there this afternoon, and we're going to try this case to the end. Now, you get out of here before I call a bailiff and have you thrown in jail.
What does it mean? I mean, how about the tactics?
Oh, yeah. They present their case, and then I get a chance, and we just cross-examine.
Are we gonna win? I mean, how about the tactics, though?
Yeah.
Don't you love the hairstyles? That was the part that struck me.
40 years ago, yeah, I think it speaks for itself, but it touches on the issues that we were just discussing.
So,
All right.
so, yeah, building off of what we've been discussing, this issue of what you can say and can't. Here's an interesting example. During a mediation session, the defense attorney mentions that the plaintiff's CPA was unlicensed during the period of employment at issue. Plaintiff's attorney angrily responds that his opponent has violated Rule of Professional Conduct 3.10 and threatens to report the violation of the state bar. Judge Santos, do we see a problem?
I do not, actually. Yeah, 3.10, just as a reminder, it says prohibits statements that are made to obtain an advantage in a civil dispute. A factual observation is not a threat. It's saying I'm gonna, I don't see a problem at all with this hypothetical. Do you?
Well, and in this, no, and if obviously we don't have all the facts here, but if the plaintiff's status of being licensed or unlicensed may or may not be relevant to the underlying dispute, so it wouldn't be unusual for this to surface. So no, I don't see a problem either, but it goes back to the issue, why are you raising it?
Yeah.
So, all right, so we should probably move forward because I know we have limited time here.
That's right.
Okay.
You want to tackle conflicts of interest?
Sure. I'll get it started at least. So obviously there's a express rule in Rule 1.7 that says a lawyer cannot, without informed written consent, underline the word informed, underline the word written, from each client, shall not represent a client if the representation is directly adverse to another client in the same or a separate matter. Interestingly, if you look through the rules, you see different uses of the word adverse, sometimes with modifiers like adverse or directly adverse or materially adverse. Judge Santos, what do you think the differences are, at least for purposes of our audience, when thinking about this as a topic?
So directly adverse and materially adverse, there has not yet been an opinion on what the differences are. I think they're, synonyms in logistically speaking. We need to wait for an opinion if there is going to be one, but it is worth mentioning that they involve confidentiality at the heart of conflicts of interest, and the struggle over defining what's adverse language we have to find what's the best interest of the client as a primary consideration. We used to use, many of us that have a few decades in now, used to use the checklist approach. We've moved as a group of attorneys away from a checklist approach to this approach of primary consideration being the client's interest. Rule 1.7 and 1.9 use adverse and directly adverse language and materially adverse when they're referring to the lawyer's interest in being in opposition to a client or former client. 1.7 is current client, 1.9 is former client. And the 3 levels of adversity. So
great.
Correct.
So
material.
In the interest in time, Katie, could you go to the next slide? Obviously, one of the key hallmarks of lawyers' obligations under all the ethics rules is the duty of confidentiality, which you can see here. I'm not going to repeat the language. Again, I put it in the category of common sense. You err on the side of confidentiality. And you are not permitted to disclose information unless you have a reasonable belief the disclosure is necessary to prevent a criminal act, or the lawyer believes it's likely to result in death or substantial bodily harm. Those are the rules. Now, in terms of timing, Judge Santos, if you don't mind, in real time, I'll ask this question. My inclination is to skip past the next videos because it'll take a few minutes and go to the client trust funds issues that I know you want to address. If that's all right, can we do that?
Let me just we can, and I was gonna, I know
yes,
that's
please.
But I just want to add that our conflict issue is not just did we have prior context, it's also exposing materials, leaving documents exposed. You have a multi-day hearing, I've done it in my courtroom. Hey, you can leave your stuff here, but you've got bailiffs and public coming in and out of your courtroom when it's open, even if they're not coming up to the table. So those also involve confidentiality and conflicts of interest, exposing medical data, et cetera. Including electronic exposure. So just making sure that I commented that all of that is included in this concern for protecting your client and confidentiality. So if we
yes, thank you. I didn't mean to skip past that. So we'll skip a slide. If anybody's interested, I'm a huge fan of the Better Call Saul series. It's a multi-year course in ethics. You can look up Google, Better Call Saul, CLE, Kim Wexler. I have no idea why they exist, but there's multiple film video segments on ethical issues. It's really, really interesting, but I want to make sure we get to this point. So we'll skip past that for now. Judge Santos, this is an issue. I know this is something you have spent a lot of time on.
I did. I can give this the short version, and I know that at least for my compliance group, it's right upon us. Why we have 1,500 people watching today. All of the requirements for the state bar. Starting February 1st of this year, so in less than a month, we as attorneys are now required to have new requirements under Rule 1.15. Of course, you can pull that up. You'll see it on the State Bar website. You'll have a note if you haven't already done it. You have to attest as to your accounts that involve client funds. I see that Katie has just dropped into the chat the CTAPP link, which is what we're talking about. And that is a requirement that we now have to declare that we are complying with I call them IOLTAs, the trust accounts. We have to declare where they are and that we are in compliance with the requirement. And the reason this new rule, this new obligation was instituted is that still, and I believe for years, if not decades, the #1 complaint issued to the state bar for attorneys is mishandling of client funds. Obviously, we as attorneys cannot take and personally use client funds. We are responsible for them. And so this new requirement is upon all of us, and the reporting starts with those of us in the Group 3 starting by February 1st to have the client trust account program requirements. That's with the CTAPP, client trust something account. In any event, the link is on the slide. And every year, we're going to now have to declare what the accounts are and attest that we are in compliance with the reporting requirements and the actions required with those trust accounts. And it talks about if you are at a firm that has one and maintains it on your behalf, there's all these different categories. If you are a solo practitioner at a firm, at an agency, we now as individuals have to make these declarations. So I don't want to read it to you. It's on the screen. The link is on the screen, and you can find it right on the very first page of your profile, whether or not you've complied. And if you haven't, what you need to do by February 1st for group 3, and then following that. But it starts effective this year. Okay.
Great. So we have a few minutes. So Judge Santos, your call. Should we take a couple of questions? We could go back to the slide, but I think these questions are more interesting to try to address.
Sure. I see that there's 30 questions, and I'll let you pick. I don't know. There's no way we'll get through 30.
Well, my list, at the top of my list currently, this goes back to, I think, where we started. Who decides if a potential client is less than fully competent? For example, if someone says that guy's crazy, is the attorney required to investigate? What do you think, Judge Santos?
No, not any random person saying that guy's crazy, obviously. You have to have a reasonable belief. The word is always reasonable as to their competency or lack thereof. And I think we hammered already at the answers to this one beyond that. So no, you're not obligated to investigate any random commentary like that. You are obligated, though, if you're interacting with a client and you have a concern or you have some professional information, you can't ignore it. So I know we're being very broad. It's always case specific. I cite you back to what we cited earlier, maybe.
Great.
And I'm scanning the questions here. I don't know how to pick. There's some political ones I'm going to stay away from that refer to make America great, etc.
A lot of questions about religious beliefs, which I think we've touched on as much as we can. Here's one. Would it be a violation of the reasonable diligence rule to seek a continuance of the trial in order to allow time to file a motion to be relieved as counsel?
Oh, that's under what context is my first thought. Are you talking a civil case or a criminal case? And you say trial, are you in a jury trial, court trial? I didn't hear that. So
it doesn't provide whether it's a civil. I mean, the question's not tied to that. I think it's a dangerous thing to assume you will get that extension too. I mean, be mindful. Even it may not be an ethical violation.
Okay, I see one here asking: are there any ethical issues with dating a prior client?
What would you say, Judge Santos?
I like the way you punt. I would say potentially prior client, as in you still have the issue of confidentiality, but again, just like the sex question, there's no hard and fast answer. The ethical issue is first questions I would ask are, first question is the case over? Is it under appeal? Is the appellate period over? Was it a one-time, single retainer where you wrote a prenup? So potentially, but there's no prohibition. I don't think that there's an ethical violation under the generic question. So what do you think, Mark?
I put in that category. If you're asking yourself the question, you probably are answering the question. You may be fighting against the answer, but if it doesn't quite feel right, or you're concerned enough to ask the question, that's probably a good indicator. Not a good idea, but again, that's an overly broad question. Okay, so let's see. We have another minute or two.
We do. Building off of that prior question, we do have one that says, does the rule mean that a lawyer in the general counsel's office can't have sex with anyone in the company because they are his or her client? So that's a little bit more specific. What do you think?
I'm going to make Judge Santos answer that one.
Yeah. I think, yeah, I love that sex has come to the forefront in the follow-up questions, hence the 30 years of debate amongst those making the rules. But I think this is a good time. We're just no way. We've answered it the best we can. Refer to the rules. I want to thank you all for having me and allowing me to present. We hope it was entertaining and worth your time and certainly your attention. I appreciate the compliment.
I also want to thank Judge Santos for lowering her standards, let me partner with her, but also thank Lucy Barron, Joanna Barron, Kathleen Emmett, of course, Katie Jones, who did most of the real work here today.
Absolutely.
It was great to be able to participate. If there are follow-up questions, I don't want to speak for Judge Santos, but I think I know the answer. Feel free to reach out to us through ADR Services if we can be of help.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.